Well, good evening, everybody. Welcome to the Manydown overview meeting tonight. As usual, there are no fire alarms scheduled for this evening, so if the alarm sounds, please evacuate immediately. Fire exits at the rear and at the side of the room, down the stairs, and we meet in the War Memorial Park. The meeting, as usual, is being webcast live on the internet. Yes, it is indeed. And as usual, could we ask if we could have mobile phones set to silent to avoid disturbance to the meeting. Right, okay. Then, in case there's anyone watching who doesn't know what goes on at these meetings, if you see someone sitting with a yellow named tag in front of them, they're an officer of the council here to help us get through our business this evening. My right and left we have the councillors who are the members of the Manydown Overview Committee, and we also have Councillor Isaac with us, who is the portfolio holder, and we're joined tonight by Councillor Harvey, who's the proposer of a motion that we're going to discuss later on. Right, in which case, can we get on with the agenda? I don't believe there are any members of the public who are here to speak. Apologies for absence and substitutions. We have one substitution, I believe.
Yeah, I'm for Councillor Peach.
Great, thank you very much, Councillor Edwards. Any declarations of interest, please? Yes, Councillor Harvey.
On all planning matters, it's not relevant, but I have a personal interest in Park Farm in Oakley. It's on my register of interests. It's not relevant, but it's worth declaring for the sake of it.
Fine, thank you very much for doing that. Paper A is the minutes of our last meeting, which was the 27th of November. Can we agree those as a correct record, please? Thank you. Thank you very much. I'm not aware of any urgent items. Is there anyone else aware of any urgent items? Yes, Councillor Potter.
Sorry, Chair, I mean, begging your indulgence, I know you call this urgent, but I just wanted to ask one thing of you, I think, if I may. We've got two main papers before us this evening, obviously paper B and paper C. Paper A, obviously, paper B deals with the initial response to the request from the local planning authority to examine the potential for additional delivery of houses on Manydown. My view, for what it's worth, is that we should discuss the paper dealing with the motion on affordable housing before we get to that paper. I mean, laying my cards on the table, I'm not prepared to support a paper that talks about additional numbers on Manydown, rate of delivery, until I'm confident about the type of houses that are going to go on Manydown. And it seems to me that a paper that deals with the affordable housing element is very significant and very important, and I would like that discussed and resolved as much as we're able to as an overview committee before we get on to the paper. They're both valid papers, but I just think they're out of sequence, quite frankly, and I'd prefer the second one to be taken first. That's my view, please.
Any other views around the table? Councillor Keating?
I support wholeheartedly the proposition from Councillor Potter. Thank you.
Well, I feel fairly relaxed about which order we deal with the two papers in. It does mean that we deal with the paper that in particular Councillor Harvey's here for first. For all we know, he may wish to, as soon as we've dealt with it, go off and go home. So I'm quite content that we take paper C next and then deal with paper B. Right. So in which case we turn then to paper C, which is Manydown, which is the affordable housing motion. Councillor Isaac, do you want to introduce this paper for us, please?
Good evening, councillors. This agenda item relates to the full council motion passed in December calling for a commitment to 40% affordable housing to be delivered on Manydown, irrespective of what irrespective of any policy arrangement or joint venture that may be taken following negotiations with other partners. When this motion was first formulated in December, officers, including legal officers, expressed concern to me as the portfolio holder about the risks to us as a council associated with this motion. What I'd like to say here, and in doing so I'm restating what I've said publicly before on a number of occasions, is that as an administration and as a portfolio holder, we support our borough policy of 40% affordable housing. I just want that to be registered once more. So why can't we do what the full council motion requires us to do? It would make life a lot simpler, wouldn't it? That's because of clear legal advice that we've received, and councillors are a party to tonight. However inconvenient that is, that clear advice exists. I think the key reason that we have this issue is that we are not the sole owner of Manydown. We have a long leasehold partner, 50% partner in Hampshire County Council, and the Manydown company, representing the trustees, remain the freeholders with legal rights to 50% of net profits. So if we embark on a pledge to ensure 40% affordable housing in all circumstances now, we'd be doing so before there's been a time to assess its impact on the viability of the Manydown development. And let's not be under any misunderstanding. The Manydown development is a huge undertaking. It's going to cost into billions of pounds. It's a very complicated development. If we commit now to 40% affordable housing, however much we all want to do that, before all the many months of work that has been done by experts on the financial and development delivery considerations, we may end up not being able to deliver a viable development. I suppose my point here is now, would our residents really thank us if that happened? Especially those wanting new homes at Manydown. And what would our partners say? And what would they do? What might they do? As a landowner, in conjunction with the local planning authority, we also need to take account, alongside affordable housing, other important considerations, other important deliverables at Manydown. Social, educational, environmental. The opportunities are there for new community buildings, for perhaps some form of sustainable energy scheme for Manydown. We know that there are going to be requirements to provide additional educational facilities. A great opportunity here, and it's going to be needed when you think in terms of the population that's going to be settling at Manydown. And there are also environmental issues that we have to look into, and great opportunities here. So these all have to be weighed in the scales. They all have potential cost implications. So I think it's reasonable for us to want time to look at all these things, as well as and not minimising the importance of affordable housing. As a public body, we have a duty to our residents to act rationally and prudently. That's why, as portfolio holder and as a member of the Manydown Executive Committee, I must take the legal advice received extremely seriously. Manydown has been the subject of one judicial review decision in the past by the High Court, and I think we'd be well advised to avoid a repeat. Final point I'd like to make is that as portfolio holder, I've reflected on the good progress that's been achieved on Manydown over the past 3 years. In that, the contribution of councillors drawn from all sides has been important and influential to me as portfolio holder. I would hope that this issue will not derail that constructive dialogue and collaboration. Too much is at stake for our residents and their future housing at Manydown. Thank you.
Thank you, Councillor Isaac. Councillor Harvey, would you like to speak to the motion?
Thank you, Chair. The first thing I want to say in relation to where the motion comes from and what me and my colleagues were driving at in response really to Councillor Isaac's points are that we are not a private landowner. This land is owned in public trust with the County Council alongside the Manydown company, who knew right from the word go what they were involved with in a public direction of travel. That's why they came to us, to achieve a greater good on the land than could otherwise be achieved through private development. That shouldn't be lost on us when we consider these issues. The question I ask of you all really is, who are we building these houses for? If you think through what is proposed in the motion, what I would like to ask of the committee is why we have a motion from council come to your committee with a report and the amount of work that's gone into it before you as a committee have debated it. Thus far, motions have been received at committee where committees have decided what they wish to do with the motions before officers have undertaken work and undertaken all what's gone on around the legal and all that's happened around this particular point. So I'm fascinated with who originated the work, who initiated the work, and why you've got all of that before you've had a chance to sit around the table, because that hasn't happened with any other motion thus far that's come to any committee that I'm aware of or I've been involved with or my colleagues have. Difference in process here. I think the legal opinion you've got raises fairly serious concerns, and I did note where the legal opinion comes from and the fact that they were involved in the failed defence of the judicial review. So I would take their opinion with a pinch of salt, but then again you always take legal opinion with a pinch of salt because it's an opinion. And if you stick 3 lawyers in a room, as you stick 3 politicians in a room, you will come out with 3 different opinions. The importance is, what is the judgments that have been made about this land? So when we're talking about development models and how you might go forward, the legal and contractual reasons behind the land's purchase are incredibly relevant. And there are 3 relevant points. The LSVT transfer and the documents that colleagues like Councillor Tilbury still have that I've seen that relate to the purposes for which the money was taken and the money was used to buy Manydown, which was a commitment from this council to build affordable housing. That is there in an agreement that relates to the sale of the LSVT, go through the LSVT, that relates to why we purchased Manydown and the reason behind using that money. The second point is Judge Lindblom's judgment, which clearly states and is a reaffirmation of the principle of delivering low-cost, affordable housing on the land. That is there in the judgment. It was reaffirmed by the judge. That isn't opinion. That's part of the judgment that was handed down. And finally, there is the council's own policy, the council's own position as a public body, not a private body, which raises the question of best consideration, which is not to deliver the maximum value and profit, but to get best consideration set against your principles. Now, if some wish to interpret best consideration as maximising profit, that I would challenge. The principle and the commitment to affordable housing should be made with no issue at all. There is no need to have the row over this at all. It's there in policy, it's there in what we're about. And the danger that this sets by not committing to it, or by not giving an absolute to it, if you like, in the way we described, is the precedent that it sets to all the other private developers coming into our borough. If we can't even do this on the land we own, how in the world do we expect every other private developer to do it on the land they own? That's the point. And when it comes to the consideration of the long list, I sat in those meetings looking at that long list. 2 primary schools costed out at £17 million. I'd love to know what they're doing with those primary schools to make them cost 17 million quid. A £600,000 library. That was on the wish list for Manydown. We'll have a 600 grand library, shall we? There was reasons why that list was created in relation to SIL and Section 106. I understand that. But let that not constrain our commitment to what we truly want to see, which is affordable housing on Manydown. That was the reason why we put the motion. It's a very brief description, Chair, of all the motivations and everything that's behind it. But if this administration cannot commit to 40% affordable housing on Manydown, it really does beg the question, who are we building all these houses for? Thank you, Chair.
Thank you, Councillor Harvey. And if you'd like to remain at the table, then you may wish to come back later on. So I'm quite content that you should stay there. Right, so open the debate. Councillor Golding,
I was going to do a question first. I'll debate it. Proprietor, you said that we're not the sole owner of Manydown. Have Hampshire now paid up, or are we still the sole leaseholder?
We're anticipating payment of the option in this month. And I think notice has been served via the relevant legal department, so the formal processes are in place for that payment to occur by the end of the month.
I'm grateful to the officers. Just apologise for my merriment, but we have heard that before. But let's see whether it happens this time.
Then I saw Councillor Potter and then Councillor Faulkner.
I'm grateful, obviously, to Councillor Harvey. He and I had most to do, I guess, with the motion that went to Council, as you know, and it's also the case. I mean, I've committed a fair amount of comment on this matter over recent weeks, as you are well aware, really. Most of you, I hope, will have read that. I won't duplicate all of that. Councillor Harvey's made the point about the legal opinion that's been obtained on this occasion, and I think probably I'd duplicate what he says in terms of stressing the fact this is a legal opinion. Obviously I have proper regard for it, of course I do, really, but I mean, he points out the fact that those are not always as watertight as you might like, and this council wrongly sought to defend a judicial challenge that led to probably £500,000 or so being wasted of public money. And this saga of Manydown has continued for many years. Council makes the point, the barrister makes the point in his opinion that he gives about the responsibilities we all have, our fiduciary duty as councillors in respect of the expenditure of public money. I mean, it's not lost on any of us, I hope. I mean, and I'm sure I can be advised differently if that's the case, but we have that responsibility all the time on just about, I hope, all of the decisions we make that have financial implications. So we could be challenged at any time on any decision we make that involves the expenditure of taxpayers' money. I mean, it's worth saying, I don't think, as far as I know, there was any appeal made to do anything following the waste of public money over the original judicial review, and we move on from that. But I mean, there was a clear example, I think, of a failure which could be described as a fiduciary duty failure on that, in that event. What I want us to do, if we can, and I mean, we'll do it this evening as best we can, obviously, is see whether we can find a consensus to move forward. I know Councillor Isaac and I have spoken on many occasions about this. I defy the logic of some of the things that are being said in this regard, and Council makes reference to it, Councillor Isaac himself has, in terms of his reply to Councillor Tilbury, one of the eloquent emails that Councillor Tilbury wrote on this matter, where Councillor Isaac suggests that in this regard any decision could be challenged, including our partners on this matter. I am struggling to find the logic of that. It just seems to me the likelihood of Hampshire County, our partner, challenging over this matter, challenging us in the courts over this matter, as I say, defies logic. I cannot understand why there could be any prospect of the Manydown company itself challenging us when, in terms of the original agreement, I don't want to put too crude a point on this, but what they are mostly going to be involved with and will be looking for is the money that will be made from the sale of the land, the uplift that comes from that, and they're entitled under the agreement to those payments to be made. It won't matter to them, it seems to me, what that land is used for in regard to the housing that's put on it. In regard to other third-party challenges, I'm trying to find identity for this, but it seems to me that could only be the sort of partners we might get in terms of any joint venture. Now, I mean, it seems to me that's within our control. I mean, it's a nonsense, it seems to me, to suggest that we would enter into a partnership with somebody that we choose. And I know some of these venture capitalists can be pretty hard spirited when it comes to this sort of thing, but we would not get into a partnership with somebody who was subsequently going to say, we will challenge you judicially that you're not making enough money out of this venture that we've willingly entered into with you. I can't see where these challenges are going to come from. And all we have sought to do in our motion is to make it absolutely crystal clear that we are committed to the provision of this housing for the people, the affordable housing for the people that we claim to represent in Basingstoke. There is an absolute shortfall in the right sort of houses in Basingstoke for people to have at the proper rent, at the proper arrangements in which they can part buy, part rent, all of those things that apply mostly, I think, to the younger generation. And we are failing them in regard to the housing we are providing in Basingstoke in many instances. I find the real irony of all of this, and you will know this, Chair, yourself, when you and I go to a pre-app meeting the other day for housing in Whitchurch, where we're actually talking to the Barretts and David Wilson Homes of this world, who are not my greatest friends, I have to tell you, but in terms of their commitment to 40% affordable housing on that site, which may take 200, they have no equivocation in saying, yes, we will do it, tell us what type of mix you want, and we'll give you that as well. I mean, the irony of all of this is, and I hate to say this really, because I have loved Manydown as a concept over many years. I'm that old. I was involved in original discussions with the original Oliver Bellises, who was a kindly man. He described himself as an independent when he was the chair of the Royal District Council I used to work for. He was clearly a conservative, but a compassionate conservative who also believed in the project at that time. But the irony is, after all that effort, you get into a situation where we might just as well sell this land off for profit to private developers and then use our planning conditions and constraints to actually get the 40% affordable housing. I mean, what a bizarre thing for me to be saying, I know, but that's the sort of frustration I feel on this. But I genuinely believe if we can find a way through this, it is to say, really, on the land that we have direct influence over, we will provide that 40% affordable housing, and we are able to say that, I think, without qualification to Hampshire County. Manydown partners as well will have no issue on that, I think, and we will make that absolutely clear to anybody else that we seek to enter into a joint venture with, although I do say, I've said it repeatedly, and there are many examples of this up and down the country, there are other models that local authorities have adopted in regard to the provision of this type of affordable housing, and we can look at those as well. Thank you, Chair.
Thank you, Councillor, and thank you as well for your your clear statement that you hope that we can work to consensus. I share that hope. And turn to Councillor Faulkner next.
Thank you, Chair. I hope I'm speaking as a compassionate Conservative here. I hate to think otherwise. I think, first of all, I've obviously only been involved with Manydown fairly recently, so I don't have the experience and background of others, but it just seemed to be at the council meeting and here that we all seem to be on the same side in terms of we're all committed to 40%. And indeed, as a council, we have a legal responsibility to implement our written stated policies. So it almost seems as if we're getting into some semantics, which I wonder why. In my experience of contracts is when the people involved in the contracts at the beginning are there, everything goes pretty well. The big problem is 4 or 5 years downstream, where you may have a lot of new people who simply look at the contract and then everything hits the fan. And I think we need to avoid that. And I think it's very, very dangerous to avoid taking legal advice. I'd feel very uncomfortable overriding the legal advice that we've received, regardless of what may or may not have gone before. And the point I make about 3, 4, 5 years downstream is we don't know where the challenges might come from at that time. The world will have changed. If we only look forward a few months, the world could change considerably after May the 7th, when a new government may come in with all sorts of different initiatives, because clearly everywhere there is an issue with affordable housing, not just in Basingstoke and Dean. And I have a fertile imagination, and I could foresee that maybe in 5 years downstream, you know, a new government may say we're going to compulsory purchase thousands of acres of land in Basingstoke. Housing will no longer be a problem, and maybe you want to now put a Premiership football ground on Manydown. I really don't know. Basingstoke are doing so well at the moment. You know, so personally, I'm comfortable with the way things they are. The commitment to 40% within our C2 policy. I don't want to go against legal advice, but I think that we're all actually on the same side of the fence in trying to achieve a solution to what is a severe problem generally.
Thank you. And now Councillor Keating.
Thank you, Chair. I wish I was convinced that we are on the same side, because I've been involved in Manydown since about 2008. And the reality is the Tory administration in 2006 stopped promoting Manydown for housing. In 2006. John Leake was the leader, and that's what happened. 2009, the Tories and the county decided to stop promoting Manydown as for a building. We had to go to a judicial review at the end of 2011 to get the proper position established by a High Court judge to say we had to build on it because we voted to build on it. Now, 2011, and we got the answer in 2012. Here we are in 2015, not one house, not one plan, not a plan. And here we have somebody trying to preempt the elected members of this committee by producing an unrequested, not by us anyway, an unrequested legal opinion. And that legal opinion is to delay matters yet further. Now, that really does not convince me that we're on the same page with everyone. Can I just say, Chair, there are 3 definitions of how housing is priced. You have the market value, then you have affordable, which is 80% of the market value, And then you have what's called social housing, which is in the order of 60% of the market value. Now, we own, never mind the minutiae of how we own it or which particular bit we own Manydown. Now, any developer, when talking about viability, will tell you, the developer must take into account the price I paid for the land. Then I must take into account the price of building the houses. And then I must have, because I'm part of the process, I must have substantial profit. Now that's approximately 33% each. 33% to buy the land, 33% to build the houses, and 33% profit. Now, we won't even go into the values or the valuations, but that's the general pattern. To build on Manydown, we wouldn't have to buy the land because we've got it. So that's the first 33% taken care of. So you could build the houses for 66% of the actual cost from a developer. You could build houses. Now, I know and you know that we wouldn't want to give away the land for free. Of course we wouldn't. But there are two current examples, no, three actually, where we contribute land for free. We, the Borough Council, looking after our fiduciary duty and making sure we get best value out of the land that we own. We work with the Housing Association Sentinel in Popley. We parcelled up all the different spare bits of land that they had and parcelled up all the spare bits of land on the same site that we had, and we said, here you are, have it all for free, but build social housing. And they did. Then we have a lovely football club, you did right, and I hope they succeed. And what are we trying to do currently? Give them free land. Now, that's not a fiduciary duty issue. Oh no. Oh no. This is a community benefit issue. Now, the reality is we do contribute free land regularly for community benefit. And there was nothing wrong with that. But then, because the guy that was what's his name? Mr. Leader, he wasn't told all these facts. He was asked to tell us that we have a fiduciary duty to get best value out of the land. And that's the nightmare we're looking at now. We're looking at opinion which is based on some facts. It's not based on all of the facts. Now, he says, his opening statement is very good. I am asked. Doesn't say when or by whom. Very interesting that we don't get that type of detail. It's not, right? Oh, I beg your pardon. It says the legal department, and the head of the legal department is Lisa. But it doesn't say when. And it wouldn't be beyond the wit and wisdom of man to say, I was asked in December or January or whatever. When it comes down to it, paragraph 6 is very interesting, right? He says, it is entirely possible that it might frustrate or thwart the development. Well, lots of things are entirely possible, and I hope he didn't get paid too much for that type of advice. Chair, I deliberately and knowingly raised in the September Ofcom Overview Committee with Councillor Isaac the reconfirmation of his commitment to 40% housing. And he was quite open and straight with us, and it's all on camera, and we've got it. And he was quite open and straight that he's committed to 40% social housing. And I believed him. I still believe him when he says he is committed to it, but the commitment seems to be watered down. It's now only if the builder will allow it, and only if the sums allow it, and only if we get best value. Now, my own view is best value. The best value is for the community, for the homeless, for the people on the waiting lists, for the people who need cheaper housing than market-priced housing, because that's why we use the money from selling council houses to buy the land in the first place. But apart from that, I'll listen to the rest. Thank you.
Thank you, Councillor. And next on the list is Councillor Golding.
Thank you. As we know all too well from past experience, the quality of the legal advice you get depends on the information provided to the lawyer, which is a point that Councillor Keating's just made. And it seemed to me there's a couple of significant gaps in the information provided here, or at least they're certainly not mentioned in the opinion. Clearly, none of us wants to do anything unreasonable, but it's only unreasonable to decide without having certain information if that information is relevant to the decision that you're taking. Here we have the information that's relevant to the decision which we're being asked to take. The barrister refers to both viability and profitability and doesn't totally distinguish clearly between the two. In simple terms, viable is whether the finances are such that the development can take place. Profitability is how much you make out of it. Now, we have absolutely clear evidence on viability. We have the Three Dragons report, which puts absolutely beyond doubt that at 40% affordable housing, even with expensive schools and other things, that Manydown is viable. He does say that you may get less profit out of it than you would if you were a commercial landowner holding out for the absolute maximum. But there is no doubt that it's viable. If we stick to 40%, there is not the slightest foreseeable risk that the development would not go ahead. Profitability, as Councillor Harvey's reminded us, one of the things the judge said in the judicial review is that normal considerations, commercial considerations, don't apply to Manydown. It was purchased under particular public ownership, public powers, and we have to handle it in accordance with those powers and not on a purely commercial basis. I think finally the one thing that I think is most crucial on this is under the lease, we all know that we have a right to if we take over the freehold because we built on it, then the Manydown estate get a payment which is calculated on the open market value of the land. And the fifth schedule, the option of the lease, says that open market value shall mean an opinion of the best price at which the sale of the freehold interest in the relevant land with vacant possession, where account is taken of any requirement for the provision of affordable housing on any part of the relevant land in accordance with the provisions of the development plan or any planning agreement relating to the relevant land. So when you do viability with a commercial landowner, you can start with some sort of base point as to what people like Three Dragons think the land is worth, and then work out whether you can still sustain 40% affordable housing with that land value. But here the lease is very clear. You take the affordable housing off first, and what is left is the value of the land. And that's all we're repeating. We want the negotiations with any development partners to be absolutely clear. You take off the affordable housing in accordance with the borough's development plan before you work out what the value of the land is. And they need to come into any partnership with us with their eyes open, because that's the legal position. Thank you.
Thank you, Councillor Golding. Councillor Isaac, you want to come in at this point? And then
if I may, just one thing, Chair.
Other people waiting.
Yes, of course. At some point, there have been various assertions made about the position of our ownership of the land and the contractual arrangements, and I think it would be helpful if officers were given an opportunity to respond to some of those technical issues.
Can I suggest that we have two members waiting to speak who haven't spoken yet, that we hear their contributions, and then I'll ask the officers to come in to clarify anything that they feel they've heard that that ought to be restated or stated clearly. In which case, Councillor Edwards is next, and then Councillor Tilbury.
Thank you, Chair. I'd just like to say that we are committed to obtaining 40% affordable housing where possible, so I do understand where the motion is coming from. However, in our local plan policy, we have outlined how all affordable housing must be viable. As an elected member of Winklebury, I am committed to ensuring that the Manydown development is of the best possible quality, and I would hate to see a situation where my residents and the new residents of Manydown were shortchanged on infrastructure improvements and on vital developer contributions due to trying to meet this impossible policy. I've spoken to the portfolio holder and officers, and I'm confident that we can deliver 40% of affordable housing across Manydown by pursuing a broad range of diverse yet affordable schemes. The problem with this Labour motion is that it ties our hands behind our back and commits us to a minimum of 40% rather than where 40% is viable, as outlined in the draft local plan. The change of policy could result in the council ending up in court and losing lots of money, which I would rather see being spent on improving infrastructure in my ward to minimise the impact of Manydown development on my residents. We have received 2 sets of legal advice, and I would think it would be quite silly, even irresponsible, to actually ignore it and to ask the portfolio holder to do the same. So, as well as, you know, it is a well-intended motion, but I don't think I can support it. And after all, what's the point of receiving 2 sets of legal advice who say the same thing, and yet we don't really listen? Thank you.
Thank you, Councillor Edwards. Could I just clarify with you 2 sets of legal advice? So we have the one from Tim Leader that we all have. So I wondered which was the other one you were referring to. Oh, what, the council's internal, own internal, right. Sorry, I thought maybe I'd missed another document, in which case, Councillor Tilbury.
Thank you, Chair, yes. I mean, one of the things I was going to ask officers was this, the issue, I got the email from Councillor Isaac yesterday where, Councillor Isaac, and this is that we would have to buy the freehold from the Manydown company at the market value, but I think that's actually 50% of the market value, from my understanding from previous ones, because otherwise we're not going to make any money, are we? We had to buy the entire thing at the market value, but that could be clarified. But with the legal advice, well, yeah, we've had a lot of legal advice, and obviously, you know, if you recall going back to the original Manydown one, it was myself and Councillor Bierman's legal advice, and what we were doing was unlawful and irrational, that set all this in train in the first place, and of course we were castigated over that. In fact, officers even suggested could be bringing the council into disrepute. Well, obviously we weren't in the end, so clearly someone was, wouldn't they? So I think one of the things when I read through this, and this Mr. Leader refers to it, finds that the council had acted irrationally. He didn't mention unlawfully, but of course if he was the same people that done the original one, I suspect he wouldn't want to mention the fact that it was unlawful, would he? That actually makes some sense now. So I think Councillor Harvey's direction on that has been very useful. So I think that's answered that question now. But the point is, you know, as speakers have said, you know, this was brought to buy affordable housing. That it was bought from the sale of our affordable housing, and it was going to provide more affordable housing. It actually says in paragraph 2 in the legal advice that the purpose of the acquisition was to promote upon it a high quality comprehensive development for housing. Well, of course, part of the argument of when it went to the High Court was that the argument that we weren't going to do that. In fact, even a month before, the Deputy Leader, Councillor J. Wadena, was saying it could end up being used as agricultural land indefinitely. So clearly I'm not sure where this part of the legal advice comes from. I mean, that's what we may have thought, that's what we were buying it for, but it isn't actually. The argument at the time was that it was for the better planning of the area, which is all it states in the Town and Country Planning Act under those particular paragraphs there. So the whole thing's a bit confused. I mean, I think I've made my comments clear in the emails, but it's the argument that we can't do this and that it could be illegal and such like. And I make the obvious point that if we're looking at a business partner for this, If we want 40% affordable housing, then the best business partner surely has got to be a housing association, not someone with just lots of money, because they also have a commitment to provide affordable housing, and that seems to me the only way we're actually going to get anywhere with this. So, I mean, I'll reserve any other comments when we've had a bit more advice on this, but I'm very dubious about legal advice we get, because as people say, legal advice is an opinion, and that's just it. And unfortunately, some of the legal opinion I've seen in recent years at this council is not worth the paper it's printed on. And, you know, as I got it right and they didn't, well, then that's one up to me, I think, so far. But having seen this one, I'm not overly enthused at some of the stuff in here. I mean, it seems to be contradictory, and it seems different to the advice we were being given before. So, and not necessarily based on the fact that they got it wrong the first time. Because if they knew this at the time, then why didn't they tell us then and save us all a load of money? Thank you, Chair.
Thank you, Councillor Tilbury. I will let Councillor Bean in next, and then we'll I'll seek some input from our officers.
Thank you, Chair, and I'll apologise in advance if this doesn't flow perfectly, but I've wrote bits and pieces all over the place. I think I'll start, as colleagues on this side have already said, that we are committed to 40% affordable housing where viable. I think it's important to note, as Councillor Edwards has already touched upon, that we have now had 2 sets of legal advice, both internally and externally, which have both confirmed exactly the same thing, and that we were provided with at full council. Just looking through the legal advice, I particularly in point 12, the important piece to me that I could take from it was that the fundamental problem in each case is that at this time officers simply cannot inform the MEC about the effect of adopting the motion. It seems completely premature at this moment in time, and for that reason I'm not prepared to recommend this motion for adoption. I have no doubt at all that this motion is well intended, but I think, as Councillor Isaac has touched upon himself, that I've got strong concern that this motion could lead to a situation where this council acts unlawfully, considering the legal advice we've been provided this evening or in the week. I think it's wrong to ask the portfolio holder to enter negotiations with the Manydown company and HCC, knowing that his position is considered to be unlawful by both internal and external legal advice. It's important as well to note that the Manydown company have taken this council to court once before, and I think that we really do need to bear that in mind. I'm not prepared to risk the resources of this council and the taxpayers' money on an ill-conceived motion, however well-intended it may be. I just also wanted to go back to a point that was raised about not being able to see where challenges will come from. Well, that doesn't give me any confidence. Just because you can't see where a challenge could come from doesn't mean that a challenge won't come in. And finally, it's also been touched upon about best value in regards to homeless people and perhaps those on the housing register, but best value is for all council taxpayers, and part of that will be the return that we do get on that land.
Okay, thank you. And I can't resist, as one of the councillors who was around at the time when Manydown was purchased, absolutely am, and indeed 2 years before that when we sold our housing stock. When we sold the housing stock, we made a very clear commitment that the money would be used to provide affordable housing. And when we purchased Manydown, it was done at a time when the County Council had published their strategic plan, saying that there should be major development to the west of Basingstoke, and helpfully, in case anyone didn't know where to the west of Basingstoke was, included an aerial photograph on the front of it of the Manydown land. And the council's view at that time of purchasing the land at Manydown was to ensure that the development there was an exemplary development. And I would like to hope that that is what we are all working towards, and that we all have an ambition to achieve the full 40% affordable housing on an exemplary development. And I'd like to go back to the point that Councillor Potter made earlier of hoping that, seeing as there is a lot of consensus in the room about the ambition for 40%, and that we do want to see the good development on that land, the hope that we might be able to draw some consensus from around the table during the remainder of the debate on this paper. But yes, officers are being invited now. I would invite, if anyone feels that they should make any points to clarify or to make sure that we are all understanding correctly what's in the paper, now is the opportunity for that.
One point and one question, if I may. I mean, in terms of what Councillor Edwards said, in amongst what she said, she referred to the motion as being a Labour motion. Can I just put it on record? This is a council motion. It was supported on a multi-party basis. It is not a Labour motion, it's a council-adopted motion. I want that to be clear. And the responsibility on us to react to that is because it is a council motion. The other thing I think that Councillor Bean was talking about was she wouldn't want Councillor Isaac to go into negotiations knowing that what he would be doing or might be doing would be unlawful. I see nowhere within the advice that we've had from the barrister that talks about unlawful. I mean, lots of things can be potentially unlawful. I've made this point ad nauseum, I think, really, in terms of any decisions we take can be challenged at any time by any external person under this general heading of fiduciary duty, i.e. we haven't spent the money as well as we should have done. But there's nothing in this to suggest that any negotiations that we entered into where we say, in my simple language, this is our bottom line in regard to what we expect to achieve from this Manydown development, is going to be unlawful in itself, and we have to be very clear about that. I mean, it's a bargaining position. I mean, Councillor Golding is far more eloquent than I at expressing the history and the background to this and the points that he has made in regard to the original lease and the like. And we would be acting entirely in accordance with the agreements we made originally, were we to go down this course. And there is nothing in that that could be challenged in law, in my view. And we can get further legal opinion if you want on that, but that doesn't undermine the negotiating position of anybody if they want to approach those negotiations in that way. And when it comes down to it, as I've said before, I think when it comes to this interesting word of profit, I mean, there are many examples of local authorities actually giving land away because what they wanted to achieve was in the social good. And I think in one of the emails, boring emails that I've sent out to people, I'm sure, in terms of European law on the Wednesbury unreasonable history, there are up-to-date examples in European court law which says, providing that what the respondent, and that's what we would be in that connection, is saying that there was a social good to what you were seeking to do, then that can form part of the defence, successful defence that you put up on that. Now, if providing affordable houses for the people that we claim to represent in Basingstoke who have not got anywhere enough of this housing stock is not a social need and a social good, I don't know what it is, and I don't quite frankly know what we're about if that isn't what we're seeking to achieve.
Thank you, Councillor Potter. Can I ask you, Councillor Keating, just to hold on for a moment while we allow, I believe we're going to have some legal advice. All right. Yes, Councillor Bean, you want to respond to something that's just been said?
Yes, please. Sorry, Chair, as I was named. I would just like to draw the committee's attention to paragraph 13 of the legal advice, and it states in here, for the reasons I have set out in the preceding paragraphs of this advice, the MEC may not lawfully adopt the motion, hence the wording that I used with knowing that his position is considered to be unlawful.
Okay, thank you. Just but you don't have to be strict about rules like being named to allow you to come back in committee. It's okay.
On that
Councillor.
point, if I may, it is not his position to judge whether something is lawful in the manner and the words he uses. It is opinion he gives us. He is not a judge. He has not sat in court. He has not given a ruling. He has given an opinion. These are fundamental points. He doesn't have any right, position, or authority to say such. And I would challenge his advice precisely. It is not, as you are interpreting it, that it is unlawful. It is not his gift to do that. There's a real difference there that I think the committee needs to appreciate. I really do.
I think the words he actually uses are in the preceding paragraphs of this advice. So he is being clear. It is advice, and it's headed right. Now let's turn to a real legal officer.
If I may, Chair, three speakers ago, I was asked to hold my case. Could I just make one sentence? Thank you. The County Council of Hampshire, in December, gave evidence to a government inquiry, and it was supporting the concept and the application of social housing and affordable housing. So the County Council's policy is to support affordable housing and social housing. Thank you.
Good, thank you. Right, now, Sue Sullivan.
Right, hopefully I can try and clarify some of the legal advice, and I know that I'm probably not going to get some of you on board this evening, but perhaps if I explain how we got to the position where we are in terms of the legal advice and why we got there, that might help. So as you're all aware, at full council, I did speak and stand to raise my concerns about the motion at that meeting, and also there's financial concerns that aren't just legal concerns about the motion as worded. Again, I note that it's all good intentions, and actually the motion reinforces the local planning policy that we currently have in place. So I understand from a member perspective it must be very frustrating when your legal services department come in and say, hang on, I'm not sure this is appropriate for you to be doing this, and there may be a challenge on the grounds of lawfulness. I just want to go back a bit and just start a bit about the purpose for which we hold the land, and I don't propose to go in a lot of detail, but there's been comments made about the purpose for which we own the land, and somebody's made reference to a statement and said, oh, I don't know where that statement's come from. So I just want to clarify where that statement has come from. So as you're aware, we purchased the land for the proper planning of the area, and the statement which is quoted by council, which is to achieve the better planning of the area by ensuring the provision of high quality comprehensive development with public facilities provided at the right time, in the right place and in the right amount. So just for clarification, that came from the joint development partnership agreement between us and Hampshire County Council, and that is our joint aim that we've got at the moment going forward with Hampshire County Council. So that's a background about why council has referred to that in that way, and he also had regard to the full judgment that he had before him. The reason that there is legal and financial concerns about the motion that's being considered this evening is because you just don't have the detailed information for you to enable you to say that, yes, we can deliver 40% on Manydown. Now, as I've said, our local plan policy position is 40%. That is our starting point going forward with this development. But at this stage, there hasn't been that detailed assessment work on whether 40% can be achieved, how, could it be more, could it be less, we just don't know. There's no evidence to this motion that's being put forward this evening. And then on the other side of the room, and I'm sure Kevin will support me, there's no ability for us as officers to say to you, these are the financial implications of the decision that you're going to make this evening. Now, this decision this evening, this motion relates to, will be made at some point. further down the line, and I know Richard's keen to have member involvement in getting to that decision, and there's discussion around, I think, workshops coming forward. So it will be made, but I think as officers, and I know it's incredibly frustrating, but we're just saying at this point in time we don't have the detailed work to enable us as officers to advise you on the decision going forward, and that work is undertaken, and if members need any further assistance about what is happening, then Richard Bailey can assist with that and fill you in on all the background. There's been reference made to an EU case, and I do apologise, Councillor Potter, but I just want to be clear on what the risks are that have been identified by Council, and it is all about this not having the evidence to back up the decision that's being made this evening, and also how can we say that we are using the value for which we hold the land, the proper planning, when we've not actually assessed the implications of the decision or what proper planning that could have, and that will only come out through that detailed process. So in terms of relevant considerations, when you look at what the case law says, is effectively you're at risk of challenge if your decision doesn't add up. So if you can't back it up, that's where you become at risk of challenge. As identified, Councillor, there is a risk of challenge. I completely concur with Councillor Harvey that he is not judge and jury, but this is Council's advice. This is an officer concern that we've then gone out to Council, and I'll be honest, I said to Council, these are my concerns, am I right, am I wrong? And Council came back and elaborated on what I'd previously advised the full Council a little bit further. So I know it's a frustrating situation to be in, but do remember we do have a local plan policy. We do have further detailed work that's going to be undertaken in relation to this, and at some point a decision will clearly be made on the specific point that's being concerned. I know Karen had some points of clarification as well.
The only point that I wanted to pick up from what was said was on the Three Dragons report. Councillor Golding referred to that, and I'm desperately trying to remember the report that went to the relevant policy committee, or it perhaps was Ofcom before it changed. But the Three Dragons report, I'm nearly certain, made it clear that with regard to the Manydown site, as it currently stands, if you needed the full package of infrastructure plus 40% affordable housing, it wasn't quite adding up at this point. But I'm absolutely certain it went on to say, however, things can change by the time a planning application would come forward. So I don't believe, and I haven't been able to find the actual document, but I don't think it's accurate to say. Yes. Oh, well, yes, but right, okay. I just wanted to pick up on the fact that it was viable, because it was the one. I think there was one or two sites which fell into that category, whereas all the others stacked up financially. And just to back up what Melanie said, in terms of the examples that Councillor Keating gave, he gave some very good examples, I thought, of where we have made those decisions. I think the difference, and from what Mel said, was that those decisions were made in having a report which clearly outlined all the implications of everything you were considering, including the financial implications. And that's all we're saying, is that at a point in time we'll be able to give you all that information, but we can't give it to you today.
Just before letting you in, Councillor Potter, as we've got a finance officer here, can I, the finance officer, can I just ask whether he'd like to say a few words on the lack of financial or availability of financial advice for us?
Thank you, Chair. Only really to reiterate what's just been said by Melon and Karen, really, in that at the moment there isn't the financial information available to be able to advise members of the implications of, in terms of the wording of the motion, to commit to providing 40% affordable housing on the site. As the scheme progresses and the work is done and the information is done, then that will be coming forward to members, and it's back to the point that Karen made, in that members will need to see all of the implications, including the financial implications, and at the moment it's not possible to give those financial implications. And just one other point I was going to make, Chair, if I may, which is the council does have a long lease holding of the land and is required to exercise an option to purchase that land, so there will be a purchase price under the option agreement, and that is also a factor that needs to be factored into and reported to members as part of the financial implications when the detail is known. Thank you.
And Mr. Bailey, please.
I think Kevin made the point I was going to make, but I think just to stress so that everyone's clear that we are not able to develop the land until we've got planning permission, and we then go through the process of purchasing the freehold with our partners. That's absolutely the position in terms of legal agreements.
No, Councillor Potter first, and then you, Councillor Golding.
I mean, if you just indulge me for 1 minute, really, in regard to, and I know it comes into what Melanie was saying. I mean, I committed to this in one of my emails, but I don't think it's on the sort of public record. But this reference to the Wednesbury, and it's a difficult word to say, isn't it, unreasonable case law that applies to this, and I hope Melanie would agree. I mean, I did quote it properly, and I think people just need to understand, because it's referred to by the barristers as well. But I mean, in terms of this English case law, it dates back to 1948, but it's stood the passage of time in regard to interpretation. And this really relates to where a public body like our own is meant to adopt this standard of reasonable behaviour and decisions. And if they act, quote, unreasonably, these are all subjective words, by the way, of course, they could be liable to be quashed on judicial review. And the statement that I think is contained in law talks about what the courts have said is that the decision, and in my view, in our case, that's the council motion, I repeat, the council motion, and this commitment to the 40% being our bargaining position, our bottom line in this regard, has to be so unreasonable that no reasonable person acting reasonably could have made it. Now, with respect, I don't see how we get anywhere near that, really, in the test that applies in law in that regard. The other thing that goes with it, and like I've said, really, there's been comments and case law, really, for what it's worth, that arises from the European Court of Human Rights on this matter. And as I've said, where a respondent is able to justify its actions in that regard, which I say are reasonable in any case, but where we to be challenged, what we have to show is that we were pursuing a pressing social need. Now, in our case, that is that provision of affordable housing. I mean, our defence where we need, if we needed to make it, I think is irrefutable, quite frankly. And I just, in simple language, want us to be more bold about this, really, in regard to the credit that we have over this matter, the assets that we have over this matter. We all allude to, you know, we all want to do the same thing, but it's a question of when we do it. And with respect even to Kevin and Melanie in this regard, I don't believe that we need all of this backcloth of all of this information in regard to the bargaining position, the negotiating position that Councillor Isa and others need to adopt at this time. It will not disadvantage us, and we need to say that, and we need to say it from the start. And it fulfills the agreements that we've made on this matter historically. And if we can't move forward on that, really, we are going to labour with this, and we'll end up, I mean, the sort of nonsense I see sometimes from developers about viability. Incidentally, viability is not always just about financial viability. If you look at the dictionary definition, it includes many things. But the sort of pitfalls that can be identified in terms of viability assessment of sites will come into play if we allow them to come into play. But if we set our negotiating position high in this regard, we can maintain that through the process. And we do that on behalf of the people of Basingstoke. We build the right sort of houses for the people that we want to build them for in Basingstoke.
I'm just going to let Mrs. Sullivan back in. Thank you.
Thank you, Chair. I do appreciate that. It was just to basically give some clarification around Wednesbury unreasonableness and what that means. And Councillor Potter is correct. The Wednesbury test is it's so unreasonable that no reasonable authority could ever have come to that decision. However, that falls under a legal umbrella, I think is the best word to use, of challenge on judicial review, which is called a rationality. And actually, if you go back down to the Manydown judgment, the way that the judge looked at it in that case is he said that it is a decision which does not add up, and he goes on to say that could be an error of reasoning. So there is, I'm confirming that because it's slight different clarification, so there are the kind of two aspects to it there. And the only other point that I just want to make is that any challenge would look at the purpose for which the council holds the land. But other than that, I have nothing further to add.
Thank you for that. Councillor Golding and
Thank
then
you.
Councillor Keating.
Yeah, I would just like to come back on a couple of points. I mean, Melanie said there was no evidence on 40%. Kevin said we didn't have the facts. And Karen mentioned Three Dragons. My point was that we don't have the evidence on profitability, but we don't need that. We have very, very clear evidence from the Three Dragons report on viability. Because what they did say was that if you assumed this arbitrary figure of land value that they started with, you couldn't get all the goodies and 40% on present circumstances, but you didn't, as a public sector body who purchased the land under these powers, have to hold out for the land value that the commercial landowners were did. And as I've said, that the agreement with the Manydown company makes it very clear that you take the affordable housing element off first before you work out the land value in this particular case. So that's clear. The other thing Melanie said was that we're being promised discussions in the future with Richard. Now, nothing personal, Richard, but that's what worries us, because the implication there is that there's a serious risk that you'll be coming back to us saying, actually, chapesses, you shouldn't go for 40%. Actually, we can't afford it. You should be going for something less. And what we want to say is we want Richard not going into these negotiations thinking, oh, I've always got the option of coming back and trying to sell them 30%. We want you going into these debates to find us a partner who knows that our position is 40%. And that determines the market value of the land. And I think the other thing that worries me, and I didn't say this previously, the formal submission to the first consultation on the draft local plan by both us as landowners and Hampshire as potential landowners was that they objected to 40% as the local planning authority housing target. Now, as far as I'm aware, neither landowner has withdrawn that. That is still the official position of both landowners, that you object to 40% as the affordable housing target. So that's why we're worried. That's why we want the discussions going forward to be absolutely clear that the council's policy is 40%, and that comes off in calculating the market value of this land.
Yes, Mr. Bailey.
Okay. Quick response to Councillor Golding, and indeed I think to everyone tonight. I'm fully aware of the intentions, and I'm fully subscribing to the intentions. The real and simple fact is it's premature to make a commitment on this right now, and so that really, and indeed the Three Dragons report mentioned that at this point in time that was their consideration. Things could change, and so when we get to the appropriate point in time, when all of the facts are in front of us, then at that point we could make a commitment, and that's pretty much what the issue is right now. It's not the intentions, I think I'm fully aware of that, it's the fact that it's premature to make a commitment right now.
Councillor Keating, thank you for waiting.
Thank you, Chair. First of all, can I just make sure that we clearly understand? This council motion was carried by a majority, and it is now the council policy. Now, that's council policy. Council policy is also in the information supporting the local plan, which we have submitted. Now, you can't say, oh, you can't implement this, and the motion falls. You have to go back to full council. It's a full council motion, and now we're having, after the event, people say, oh, that was all wrong, you shouldn't say that. It's too late to say that. If you don't want to implement a council motion, then you have to go back to council to get it changed to what's happened. There's absolutely no doubt that I expect, now, I have high expectations, because we have good officers. I expect council officers to achieve or to set out to achieve our policy, right? The impression given is you set the policy and I'll find a reason why I can't implement it for you. That's the impression. And if you have that impression, and it's not unique to Councillor Keating, if you have that impression, you're going to end up saying, I want to make it cast iron. I don't believe we should need to make anything cast iron. We should make policy, that's what councillors do, and council officers paid by us, reporting to us ultimately, should be seeking to achieve that policy. They shouldn't be seeking to find loopholes, ways out, delaying tactics, let's go to the legal people after the event to stop it happening. And that's the problem. Thank you.
Thank you. And I can see our interim chief executive, co-chief executive. Is there a longer version of that? Joint interim. Yes. Please.
I just wanted to clarify, because I would completely agree with you, Councillor Keating, about the role of officers, but this motion was not agreed as per it's worded by council. It was agreed to refer the wording of that motion to this committee for debate. Clearly, any decision around whether this would become council policy or not, under our constitution, it's an executive decision, so ultimately it would have to be made by the Manydown Executive Committee. But the motion was agreed to be referred here for debate, so we're not coming in after the event. We were simply coming in with a report to help or to try to assist your debate tonight before you refer it to MEC for decision.
Right, thank you for that. Right, we've had sort of an hour and a quarter of a discussion with some very strongly held views. And I'd like to now suggest that we actually look at the recommendations that we are given. So the easy one is that we note the content of the report. We have noted it, and there have been many comments made upon it and on the subsequent legal opinion. The comments on the contents of the report, I would suggest that as a first comment, that I could say that from all sides of this committee, that we have a strong ambition to achieve 40% affordable housing on Manydown. Yes? So there's one comment. Then moving.
Actually, we should say we have a commitment.
I think there would be differences of view over using the word commitment. But what I've heard is a strong ambition. Councillor Faulkner, are you committing?
Yeah, it's I suppose it's the semantics of what exactly does the word commit mean, because at council we removed, as I remember, the word minimum and the word commitment. So could we have clarification on what this commitment means, because it seems to read the same as our C2 policy.
If I can answer,
give us a
that,
dictionary definition? Yeah,
the commitment is the same phraseology produced by Councillor Isaac at meeting after meeting. I'm committed to 40%. That's what he said. Thank you.
On your first point, it depends what other points are going to be. I'm happy to sign up to whatever you said as strong ambition if there are stronger words that follow it, but if that's all that's going to be said, that's too weak.
I think while we're quite happy to let you in, Councillor Isaac, what I was going to say next is that also as a comment from the committee, as a statement of fact, that members have expressed concern about the legal position that the council would be in. Now, if you want to qualify that by saying some members of the committee were concerned about the legal position that the council would be in, I think that's a statement.
Yeah, just to respond to Councillor Keating, and about my use of the word committed, a commitment, yes. But this has always been on the understanding that we have to meet the tests that we have ourselves as a local planning authority in deciding whether a scheme, particularly of this scale, is viable at the end of the day. As we've said around the table today, there is a shared desire here, and the words that the chairman, the chair has used of strong ambition are words that I think are a good way of expressing what it is that we want to achieve collectively here.
Right, I think Councillor Potter had already indicated, and then Councillor Harvey.
I mean, I just want to say, Chair, I mean, I know as difficult as it is for you really with the role of the overview, but I mean, the chances of finding a consensus in terms of all the points to be put to the Manydown executive is unlikely, I think, really. I mean, there are some fundamental differences between us, I think, in terms of interpretation. I mean, some of us, I say it for myself first, but I mean, I won't accept that no further action is taken with the motion at this time. And that's the exact opposite of what I want to see happen. And I've said it out, again, not so eloquently as Councillor Golding in regard to how that should be a position that we could adopt with absolute conviction. And if that's the case, then, you know, some of the other stuff, to be frank, is padding around the edges, really. And I don't see the point of working at that. We might as well have a verbatim transcript from Stefan on this, really, with all the things that have been said, really, which go to the executive. I'd like to see the Manydown executive stop in its tracks in a few days' time and not do what it's being recommended to do at the present time. That's the fundamental difference between us, I think, really. And for that then to be a position that the portfolio holder, Councillor Isaac, is able to adopt properly and start negotiations in the way that some of us described. But we're not going to find a form of words. I mean, we can all talk about our ambitions. We've all got that. But how we want to see that applied is a very different thing altogether, I think.
Well, thank you. I must confess that I had not anticipated putting that particular bullet point to the committee, because I didn't foresee there was going to be any agreement on that. But Councillor Harvey and then Councillor Tilbury were waiting to come in.
Thank you, Chair. I've listened carefully to what you've all said this evening, all of you sat around the table. Having sat through ARGA, having gone through Ernst & Young, having gone through all of that in the way that legal opinions were given and legal opinions were changed and legal opinions were advised, and in no way, shape or form do I criticise in anything I say our officers, because you're giving your professional advice, is what you're here to do. But I do make the point that colleagues presented a motion to full council where they detailed legal issues regarding the Manydown and were told you must withdraw it. The amount of pressure certain members came under to withdraw that motion that December was huge. It didn't get withdrawn. It went to council and it had a legal consequence, and that legal consequence was the JR that was carried by the judge in the manner in which he did. That was set against the backdrop, with all due respect, of what our officer team professionally did defending this authority, alongside the advice they were given quite legitimately and appropriately, by those chambers they sought it from. That's fine. I'm not in any way... All I'm pointing out is the point that legal opinion is an opinion. And in that position, this authority backed itself into a corner it couldn't get out of, and it was found to have acted unlawfully by a judge. I think those arguments need to be tempered. They really do, because I've heard them so strongly put round the table this evening, with the actual agreements, the purposes for which we did buy the land and what the money was used for and where the money came from and so on. All of that is as equally as relevant and as equally legal. Because for anybody to challenge it the other way, as to say to this authority, how dare you use our LSVT money to buy land to develop market housing? Because that was not the purposes for which you used the money in the original point. There is exactly a counterpoint to the arguments that our legal professionals have put. Both sides of that are just, both sides of that have value in a legal debate. You can't come to a judgment over it, it's just part of a debate. It disturbs me that we've talked about wanting developer contributions over affordable housing, and that we've debated whether or not we pit one set of taxpayers against another. I really don't think that's an avenue we want to go down, and I don't believe that's where the Cabinet are going down. That's not where we're going down. It's been iterated tonight. That has been an argument that's been used. We don't want to go there. That's not right. What we are about, and what we're all about, is the appropriate use of the land for the purposes which we wish to get out of it, for the social housing, for the housing we want, as much as the other elements. And this is where I have a problem, Chair, with coming to a conclusion on a recommendation. If this committee advises the MEC that viability in any way, shape or form is relevant in the way it's been used and described, I have a problem, because I know the industry and I understand the term viability in the way that it is used. Usually around a 17 to 20% developer profit that a developer wishes to take out of a site for its own profit, not to put back into the site, not to use for the best development of the site, but as a profit for the site. So if that's what we mean by viability, I have a problem with it. If we mean by viability how you will take the total of the site and use it for the best uses, such as developing 40% affordable housing and all the rest, as Councillor Golding quite rightly describes, we've got all that evidence. And if the financial arguments that were used in EPP to justify having no sill on Manydown and having Section 106 as detailed as it was are relevant, because they were made, and that's the evidence, financial evidence, we have presented to a local plan inspector. We've done a lot of work on this when it suits us to do that bit of work. That's my point. Our affordable housing policies are there, the evidence base is there from the strategic housing market assessment, it's there in terms of the housing arguments we're making for 40% affordable housing on every other site that comes into that local plan. Why in the world would we seek to suddenly introduce on our own publicly owned site the idea of viability if it means, and if those who are using the word mean, what developers and private developers mean by viability? I have a real issue with that, Chair. If I could draw to your attention just 2 points I think would be very relevant to your debate. The development model that you choose. That is so important to this debate. If you choose to go with a private developer, that will shape what happens on Manydown in a fundamentally different way to if the land is held in public ownership and is developed like many other authorities are doing. There is some, I mean, you've seen it yourselves, there is some amazing best practice out there with local authorities leading developers and models. I mean, Ebbsfleet is one, I can think of Bicester, I can think of the one you've been to see down in Poundbury. There's so many different examples out there around the country of where you are involved with as local authorities in developing land where it is being used by sinking 100% back in. We did it on Oakridge back in the early 2000s. You took all of the developer, the money, the capital receipt that came out of Oakridge, and this authority sank the whole of that back into Oakridge to achieve the affordable housing. We didn't take any profit. We didn't go through all these legal loopholes. It was done because it was the right thing to do on that site. That's all we're saying. We've done it ourselves on so many occasions to achieve the sort of development we wanted to see when our land was involved. This is no different. So those development models, I think, Chair, are incredibly important to this debate because they shape the kind of conclusion you're wanting to get to, in particularly around the affordable housing. And if I might just say, they are about public models and mutual models. It's not about flogging the land to a private developer. And I really hope, and I do look to the Cabinet, that they have no intention of simply handing the land over to a private developer, that we would be publicly involved from start to finish. That's what I'm looking for personally. Thank you, Chair.
I'll allow you back in a moment. Councillor Tilbury was waiting to come in though.
Yes, thank you, Chair. Yeah, I mean, I think thanks for Mel for the clarification on with the JDPA statement. But both that statement and the statement under Section 226, both are very clear that we bought the land either for the better development of the area or to promote high quality development, comprehensive development of housing on it. Nowhere did we say we bought the land to make a load of money, you know, and yet we're talking about viability, profitability. All this comes out in the advice there. And if you start looking at viability, I mean, Paul will remember, because we were on when we looked at this viability, and the final meeting we had was with the district valuer, with himself and Keith Watts as well, you know, and it was actually someone who'd come from work in the development industry and gone to work for the district valuers. And of course, what came out very clearly in that is basically viability is just a ruse for developers to avoid paying any money for the public good. It's about avoiding that and maximising their profits. And he was very open about that. You know, he really was a poacher turned gamekeeper in that respect. If we look at the viability and all the issues around that, if we were to sell the land to a developer and say you don't provide any affordable housing, they would make a very large profit on it. If we actually kept the land ourselves and said we're just going to build council houses on there, we probably wouldn't make any profit, so there wouldn't be a market value for the land. But of course that would be very unfair on the Manydown company, the only organisation who come out of this whole fiasco with any credit, really, aren't they? They've at least tried to do the right thing for the public good. The council has thwarted the public good certainly from 2005 onwards, dragged us through the courts, and this just looks like another attempt to do the same again, to say, oh, it isn't going to be viable, we can't make money or whatever. I'm not interested we don't make any money on this. We bought the land, we took the money for the council tenants, we basically stole their houses, handed them over to a housing association, gave them very poor tenancy agreements on the basis that they would be better off because rents wouldn't rise, and the rents have gone through the roof. They were totally stitched up over this. This whole thing is an absolute disgrace. And the idea now that we can't possibly provide affordable housing on there, you know, because we've got to allow for all these other things there, this is just getting worse and worse. I mean, you know, we've just taken the money and now we're basically just trying to hand it over to developers, basically. And I think I just really losing the will to live with Manydown. This is just getting really out of hand now. Thank you.
Well, I would urge you to try and keep your belief in local government and retain, please, the will to live. Before I let the portfolio holder in, Councillor Bean.
Thank you, Chair. It's been suggested, I believe, that we don't need to have all the detailed information as suggested by the officers to make a decision on this motion that's before us, and I just want to put on record that I'm not happy to support that suggestion at all. Back to this legal advice, point 12 clearly states, and I will repeat it again, the fundamental problem in each case is that at this time officers simply cannot inform the MEC about the effect of adopting the motion. There was also an assertion made in regard to the judicial review, the legal advice that we received and the offer advice prior to that. And I can't draw a conclusion on officer and councillor advice this time based on what happened previously. I can only base it on what we've been told this evening and what I've read in front of me. And I think it's also important just to draw back to the recommendations to the committee is that point 3 and point 4 is that we're agreeing that no further action is taken with the motion at this time, so it's not saying we're not going to take any action and that's it, it's gone away. And point 4 goes on to say that agrees that the motion should be considered at the appropriate point in the future when the required information is available. And I think I just want to reiterate to the committee, we're not saying no, we're just saying we need the detailed assessment work before we can make a proper decision.
Thank you. Councillor Isaac.
Thank you, Chair. Just to respond, there have been a lot of points made this evening, but just to say briefly that firstly, I think there has been clear officer advice throughout, and we have, and that's been supported by legal counsel. I think it would be foolish and reckless of me as portfolio holder and member of the Manydown Executive Committee to ignore that advice, whatever how inconvenient it is. Secondly, just to reassure Councillor Harvey that, and we've made this clear throughout, that we as a council, and this is a view shared by our partners at Hampshire County Council, we do see an important role for continuing public involvement in the development and bringing forward of Manydown. We think that's going to produce the best results, and we look forward to working with our partners in future, even those, dare I say, from the private sector who may be motivated by that dreadful word profit. And if I can then just continue at that point, I've heard a lot tonight, particularly from Councillor Harvey, about which is effectively anti-business ideology of his, which is to say that, you know, that well, it's true. You know, let's face it. You talk about viability and profitability. Profitability, it's a question of how much profitability there is, but this council cannot finance Manydown on its own. It hasn't got the resources to do it. It's going to need to bring in experts from the private sector. It's going to need to bring in private investors, and they will want a reasonable return on their money. And what that return is has to be decided. But the other point, and it's a point well made by Councillor Bean, is that we as an administration, as the MEC, have a fiduciary duty to residents, not only those who will want to occupy affordable housing in future, but we need to make sure that we get the right sort of return on the money that we're going to be investing in Manydown. We also need to have enough money to provide these other facilities that we talked about, the social and the environmental and the whatever it was, the other facilities that are going to be developed on Manydown in the future.
I think if we go on for any longer, I think we're going to get more and more entrenched and more repetitive. I very much hope that the other members of the Manydown executive have been glued to their screens following every word that's been said here this evening, and if they're not, then I trust they will find an hour and a half between now and Friday afternoon to listen to it. And of course we all have the opportunity to attend the meeting on Friday afternoon and restate in our own words. I rather think that the formal minute for this meeting might say that on all sides we have a strong ambition to achieve 40% affordable housing on Manydown, and I suspect that the minute will need to go on to say that we encourage members of the Manydown Executive Committee to follow the debate and to watch the webcast to understand how deeply feelings have been expressed this evening. I don't think for a moment that we are going to move little 3, which is agreeing that there's no further action taken. How about little 4, agreeing that the motion should be considered at the appropriate point in the future? Some members are content that remains as a minute. I rather suspect that others will feel they would prefer it to be taken now.
I think 4 falls. If 3 goes, 4 goes with it.
4 goes with it. So it falls. The only other thing I might throw in just to see whether it has any support is whether we want to send any other message to the MEC along the lines of saying, because I think we can see clearly that, well, we don't know, but we can predict that the MEC is going to reject the motion. Do we want to add anything in that if the MEC does reject the motion on Friday afternoon, that we hope that it does continuously work towards achieving that commitment as soon as it feels it has the information available, and that it's not lost totally.
I would be happy with that, although the barrister did say he didn't recommend an aspiration either, but that's another point. But what I would like to do, because the minutes will be the permanent record of this, and people will not all going to go and watch it. So I would like there to be something with that. I don't want it quantified, but I think you should say a number of councillors supported, whilst recognising the legal advice, felt that we did have enough evidence at present to support the motion. I think that's a simple way of stating it, and I think that should go in the minutes.
I think that's a clear statement of fact that that has been expressed around the table.
Yes.
Yeah, I'm just making sure that Stephanie has. Yes. Is there? So the points we're making is that we've got this, we're doing what we're asked not to do, advised not to do, but we are, and we do want to record some ambitions. So the strong ambition, the encouragement to MEC to work towards as soon as possible being able to make this commitment. And as Councillor Golding just said, if you could read that back to us. Yeah, please.
Just perhaps one tiny bit of clarity. So at the moment I've just got on what Councillor Golding said. A number of councillors supported, whilst recognising the legal limits of the motion. What I think I said, sorry. So no, I was kind of waiting for the punchline from you. Oh, sorry, yeah.
What I think I said was that a number of councillors, whilst recognising the legal advice, felt that we did have enough evidence to support the motion at this stage.
I mean, I'm very grateful to Councillor Golding as usual. I mean, it's a simple matter of fact. I mean, I don't know what your position is, Chair. I'm unsure of this, of course, but the majority of the councillors support that position, I think. That's the fact.
Sorry, I'm just agreeing and suggesting that rather than saying a number of the members, that it should say a majority of the members present. Right. Thank you all. That's very important discussion. I know we spent a long time on it, but it's such an important issue that I don't begrudge that time at all. So do councillors feel they need a break before we carry on to the, I had a feeling there was a bit of restlessness. Yeah, we'll just have absolute 5 minutes at the absolute maximum, so please hurry back. A short comfort break. I think I think we've had our 5 minutes, so I'd like us then to move on to the discussion on paper B, which is the paper on the local plan additional delivery on Manydown, which is also a paper that's presented to us by Councillor Isaac, who may wish to introduce his paper to us. Thank you.
Thank you. Right, yes, thank you, Chair. This agenda item concerns the request from the local planning authority, the formal request to Basingstoke and Dean Borough Council and Hampshire County Council as joint owners of Manydown to help with suggestions for additional housing in response to the comments made in December by the inspector. As landowners, both councils have responded positively to this request. We both, particularly as far as Basingstoke and Dean Borough Council is concerned, it's important that there is a local plan that is approved by the inspector through the examination in public. We've offered to investigate providing some 750 additional homes in addition to the 3,400 already proposed for Manydown up to 2029. But as the report makes clear, this is subject to any additional housing that we may wish to offer is subject to the results of technical investigations, especially in connection with the Five Ways junction.
Thank you very much, and I see Councillor Keating already, so let's go to Councillor Keating.
Thank you, Chair. My current contribution will be about the map of Manydown. So one of you will be able to help me, I know.
Could we perhaps have the map on the screen?
Mine is not coloured.
Yes, that's why it's there.
Yeah.
No,
Yeah. But
it's much easier, isn't it, with colour on the screen?
During the process of developing the where we were going to build initially, the road that we were shown, which borders the top part of the Manydown site, we went on the Newbury Road, then we turned left towards Wootton St. Lawrence, and at Wootton St. Lawrence the road then turned left again down towards Worthing Road. Now, at that time we were told that the land from Wootton St. Lawrence was up to the road, and Manydown owned the land, all the land up to the Wootton St. Lawrence Road, the road that leads to Wootton St. Lawrence. Am I correct in interpreting that correctly?
Let me see if Mr. Bailey can
Hopefully, yeah.
clarify that for you.
the point where Wootton St Lawrence is, we do own, the Manydown owns the land up to the road edge. Is that correct?
That's correct, but that land that you see there is...
No, I'm getting there, I'm getting there.
Okay.
Okay. Because this map shows us having bits of land to the edge of the road from Wootton St Lawrence to Worthing Road not being built on.
So there you
Let me
can see-
show.
There you can see the boundary.
Yeah.
Yeah?
Yeah.
Okay. Can I just operate with this?
It might be the same.
I think it's the arrow keys, Richard, just...
The keyboard will be off in front of you.
Right. I see. Right, sorry. Sorry, Councillor Keating, just make that point again. Apologies.
Okay, if you take the piece of land,
Yeah.
which is above the A, is it above the S?
Are you there?
Yeah, if you take that piece of land there, which is white or greenish, light green,
This piece of land here.
yeah. On my map, just below that, there's a white patch.
Yes.
I'll
Yeah,
show. I'll
just there.
show it. Yeah.
It's the light green
Okay,
bit.
yeah.
Can I just show you?
Yeah.
If I may.
Yeah, I think it's come out white.
Right. Well, I can only rely on the information I'm given. Don't you think?
Yes, well, that's why we've got the map
Right.
here. Yeah.
That land is not currently allocated to a park.
Oh,
It's
no.
not currently allocated to housing, but it could be allocated to housing. Could it not?
Right.
That's the question.
Okay, just technically,
Right.
technically there's no land allocated to a park yet. There's no land
But that's
allocated
not
to a
true,
park.
Richard. All the maps we've got show
Technically,
maps show park.
yeah, technically.
I'm worried that this is going to get lost because
Yeah, me too.
there's a speaker on here, so I don't know whether it's possible for you to
Yeah.
speak into this speaker at the same time as pointing at that.
Technically, the land up there that's shaded in green, various points of green,
Light green, yeah.
is, and in fact there's a boundary. You can just see the boundary there, the sort of dotted boundary below the red boundary. That is the land that's covenanted not for development. So that's the covenanted not for development. So that's
Right,
the
yeah.
technical allocation, or not even allocation. That's the technical designation of that land. It's
Right.
covenanted not for development.
But am I not correct in recollecting that Councillor, what's his name, the planning chappie?
Raphael?
Councillor Raphael chopped out a piece of land to the left of the farm shop on Worthing Road and ran up the side of the allocation. Did he not cut out a piece of land for development? What he called a ridgeway.
I think that was in the past, back in 2013. What is now allocated in the local plan that's gone to inquiry is, you can just see there, the where the red hatching is, including this kind of rather brownish hatch here. So all of this land here is in the allocation that's in the local plan, and so therefore that western boundary that's gone further west is subsequent to the summer 2013 discussions. This boundary is now being reinstated there, and that's the boundary that we're operating on, because that's the one that's in the allocation.
That's a roadway boundary.
Is there, yeah, pretty much, yeah.
That answers the question. Thank you.
Thank you for that, Councillor Keating. It's gone. See, no one interested in. Councillor Tilbury and then Councillor Golding.
Yeah, I mean, could someone The first bullet point on page 10 of 32 is regarding the increase of the density. I think this came from the planning inspector sort of raised this at the exploratory meeting. I seem to remember this sort of coming up. But do we have any indication of what the impact of another 150 houses on there? It doesn't suggest an increase in density levels, because obviously we're talking about high development. It's not going to double the density, I wouldn't have thought, but it doesn't suggest. We're looking at 10 years. We're sort of looking at part of the plan period. It sort of suggests 150 in 2000. Is that, what sort of increase are we looking at there? The other one is obviously the full development of plot 6A, which on here it actually shows it as 6, but I assume this is the Pack Lane triangle, and it talks about the improvements to the Five Ways junction. Well, I think Five Ways is the least of the worries with that junction now, and the big issue is the Pack Lane bridges, which are there though. One of the major impacts, because I think we always assume that if we build a housing estate on the edge of Basingstoke, everyone would drive into Basingstoke to work, but that's not the fact. And we know that's not the fact from the numbers of the vast, or I think increasing majority of people drive out of Basingstoke to work somewhere else. Probably not helped by the fact we keep building on all the industrial sites and offices, but that's the point. We always have this assumption that Basingstoke is the focus of these things, and people move there because it's only for Basingstoke, when in reality we know that people in Beggarwood and these sort of estates drive up to London down the M3 all over the place. So I think that's Five Ways is an issue. It's a signalised junction. It's controllable there. It may need work, but what do you do about the bridges at the other end? Apart from anything else, they flood every time it rains hard. So that doesn't seem to be addressed in any of this.
Yeah, we got an immediate response to that.
Just 2 points. I think there were questions there, Councillor Tilbury. One was around the 150 on the district neighbourhood areas. Some of that obviously could be that we would build out those district neighbourhood areas quicker than over the full life of the development, which would be beyond 10 years. So some of that 150 would be just bringing it forward a bit. And the point about transport implications is well made, and obviously the local planning authority would look at the transport implications across the network of additional houses, not just at Five Ways.
I have a couple of questions. Am I correct in saying that the responses proposed in paragraph 322 increase the number of houses that would be delivered on Manydown to 4,150 during the life of the plan? No, I see my maths isn't.
This response is split out into land that is under a leasehold between ourselves and Hampshire, and land that's in third-party ownership. And so what the response is saying is providing three options for the local authority, which cumulatively, if they chose and all the relevant technical assessments were able to justify, would get to an additional 750. But that is only on the land that we have a leasehold in with Hampshire. It doesn't include other development on third-party land within the planning allocation area, which is obviously something. Let me just point out very quickly.
Right, but the 3,400 does include third-party land.
Yeah, that's correct.
Right. So, if delivery on the third-party land was unchanged, the total would be 4,150.
No, not necessarily, because there has been, I think, a planning permission under appeal being given for some of that land on third-party land, and there is consideration by the other third-party landowners in and around Worthing about whether they would want to bring forward some housing, which we have no information about just at this time. So that's not necessarily the case that it would be that amount overall.
Councillor Golding.
Let's ask a supplementary. I've got some points. But it must be at least 4,150. But when you're saying no, it can't go down from that number.
It rather depends on whether the local authority chose all of those options that I'm putting forward. So they're not necessarily there as we're saying we need or we would like all of that 750. We're giving the local authority some options which cumulatively could come to 750. Does that make it?
All right, my next question then. When in 2012, the proposal we made at that time was, which we helpfully have in the papers here, which was an email, which I now can't find, was 4,100 houses plus houses on. Yes, thank you. 4,000 houses plus 400 on site 7. So the total we're now suggesting is less than we'd originally suggested to the LPA.
Two factors here. One, we're not including any suggestion for Site 7 or Plot 7 in anything we're putting forward. Two, the third-party land was not included in that figure of 4,000.
I will come back in a moment. Councillor Golding, I think you waited.
Debate, not question. So
Then my next question then is why are we? Is there a reason why we are not considering Site 7? I was going to say strictly in order to be helpful to the local planning authority.
When we had a look at the additional potential additional land that we could offer for consideration by the planning authority, and again just to re-emphasise, we're offering 3 options which cumulatively come to 750, but the planning authority may only choose to take 1 or 2 of those options. We felt that the 3 options we offered were probably the technically the ones subject to the further technical work that were best deliverable within the local plan timescales and would fit better, particularly around 6A and other parts of 6, with how we would comprehensively plan those areas in the earlier stages of the development, rather than sort of separating development across large spans of the development itself.
And do we have a feeling for the timescale for the technical studies? And this is also follows up the point that Councillor Tilbury was making about being sure of impacts on Pack Lane and Five Ways Junction.
Just in terms of the technical studies we're doing, which we'll obviously share with the local planning authority, they should be complete within the next month or so. But obviously the local planning authority have to do their own technical studies as well. So they're not going to rely just on our technical studies, they're going to do their own technical studies as well.
Next month or so, does that mean we're likely to have them to consider at our April meeting?
Yeah, that's correct.
Anyone else wish to ask questions? If not, Councillor Golding wanted to come in, we'll start the debate.
I mean, I think 3.2.2, page 10 of 32, is the essence of what we've been asked to address. So my personal views, I don't have any problem with the 150. I don't have any particular problem with the areas of land involved in the second and third bullets, or indeed the numbers, subject to the bit which says subject to a revised solution to Five Ways Junction. And contrary to what Councillor Tilbury said, that is a very serious traffic issue. The Highways Authority formally opposed the development that was put forward on south of the railway line in their response to the initial consultation on the grounds of road safety at Five Ways Junction. Hampshire have been trying to find a solution to it for the last 10 years and have so far failed to come up with one. Our own borough Transport Study has done 2 designs. The first one concluded was the one to which Highways objected, as it wouldn't sustain any housing south of the railway line. The revised design, I think, persuaded the local planning authority part of us that you could get 350 houses on. There is absolutely no evidence whatsoever that a revised solution to Five Ways Junction would be possible, and I personally think it would be unreasonable in the technical sense to put it forward in the absence of the necessary evidence. So let's wait till we get the evidence at our April meeting and then decide whether to put these forward. Thank you.
I think your words make my heart sink and think, oh no, we're into whether we're being Wednesbury unreasonable or not.
Are being invited to make a decision without evidence.
I think the statement does say that it is subject to. I'm sorry, who was indicating? Councillor Potter, come on.
I mean, that's not an invitation to rush away and get another legal opinion, by the way, I hope. But, I mean, I'm grateful again to Councillor Golding in terms of his analysis and logical analysis of where we are on this. But, I mean, mine's more of a political comment, I guess, really. To be frank, and this is why I asked for this paper to be taken after the other, I mean, as I have no assurances that we're going to deliver 40% affordable housing on the 3,400 figure, why would I want to support 4,000 plus? Quite frankly, it exacerbates the situation as far as I'm concerned. And I certainly wouldn't want to, as things stand, support this being put forward to the Manydown Executive Committee. But I'm sympathetic with the position the LEP finds itself in. Local planning authority finds itself in, trying to satisfy the inspector in regard to the numbers that we're offering. But at this juncture, I don't support that, and I think Councillor Golding is right. There's insufficient technical evidence to support it. It might be available later, and we'll look at it then. If it's April, that's not very far ahead, and that's good, I think, in terms of the sequence of things.
Any other contributions? Yes, Councillor Tilbury and Councillor Keating.
No, just to say, no, I wouldn't suggest to Councillor Golden that Five Ways isn't a problem. I appreciate it is a problem. It's the other end's is almost as big a problem. I think that's the reality. But as he said, you know, this has been gone through. We are aware of the issues there, and I mean, Hampshire might say they can support it by changing the phase and that thing. But you know, you're talking about a large number of houses, and not just on one side of the road, because I think we seem to be looking at the other side of the road as well now. Whereas one time they were looking at 750 in the triangle with a 6 on it, but I assume this is sort of looking at the other side of the road there, and you've basically got a very constrained sort of site there, whereas the old Kempshot Lane site, the semicircular one next to it there, I mean, that was very contentious when that was built, you know, and there was talk then of it should be part of the Manydown piece, but that was done by basically feeding everything through buckskin, really, wasn't it, which is causing problems there. And that's, well, I think it was 303 or something like that from memory, wasn't it? That's causing a problem there. They're putting these ones out onto even worse roads, is you know, even worse. At least the other one goes out onto a sort of traffic lighty junctions as well. But you know, we keep cramming these bits onto all these roads there where the real concern, and saying that, you know, even if they could come up with an issue around the Five Ways junction there, you know, anything you can do with those railway bridges, it's going to cost millions of pounds, isn't it? And this is one of the things we come back to with the idea of Manydown doing, you know, and doing a high-level development. Well, if we do that site in isolation, we're not going to do that. It's not going to be part of the other Manydown development there, and I don't think it ever will be anyway because of the railway line there. It will just become a standalone development tacked onto the other one there on the edge of there. I mean, you know, we've already seen the Worton Farm one that went through, which is a pretty awful development around, which is totally obliterates Worting as a separate village, isn't it? It's this will just be a large development on its own next to a railway line, you know, and does that sound like a sort of, you know, high quality development right next to a very busy railway line? Doesn't sound very high quality to me, does it? I mean, it really needs to be a buffer zone, if anything, doesn't it? And the same on the other side there.
Right. Councillor Keating.
I don't mean to belabor this point, but it is a serious intent to try to clarify. If the piece of land that Councillor Ruffeld. I keep forgetting his name because he said it incorrectly. That Councillor Ruffeld actually cut out of the plan. At that point, we were talking about the restricted piece of land produce and the rest of it producing 3,400. If we've now gone to the edge of the road, beyond the farm shop, I mean, there ought to be space there to build more than was previously planned.
At the time that the original local plan submission was went out for consultation with the restricted boundary, in your terms, Councillor Keating, the total for the whole area, including third-party land, was 3,080, 3080.
So for clarification, the extra bit of land that we put back in, Councillor Ruffeld was looking somewhere else, would give us 3,400.
Yeah, it contributes to it because actually the whole area includes third-party land as well.
One final point. I live about 200 yards away from Fireways Junction, and there's houses on all four sides. Unless you buy houses and knock them down to make a proper junction, the likelihood is you'll never get a hugely effective junction. Thank you.
I think we all look forward to seeing the technical studies at our next meeting. Right, what I've heard is we're asked to note the contents of the paper, which we've done. The comments that we're providing are that I believe we are supporting the suggestion of increasing the density of the proposed district and neighbourhood areas around 150 houses. With plot 6A, we're raising some concerns about the junction at 5 Ways, and would need to be convinced that that could be managed safely, and also not shutting our eyes to the other end of Pack Lane, where it does that nasty bend under the bridge that floods all of the time. Those are the key points that members have raised. Councillor Potter?
Well, I did say, I think, as a preamble really, if I'm not guaranteed, I'm not assured, sorry, it's not for me, if I'm not assured that we're going to get 40% affordable housing on the lower number, I'm certainly not supportive of the higher number, which exacerbates the problem any further. So that's my position.
Councillor Golding.
And just to be quite clear, the 5 Ways affect 6 and 6A. I think you only mentioned one of them. It's both the second and third bullets.
Yes, you're quite right. I think it's referenced in both, and we note your concern about 40% affordable housing, Councillor Potter. In which case, can I say that that's our comments that we'll pass to the NEC, and as
on the actual report does refer to the full development of plot 6A and says see figure 2.1 appendix 2, but figure 2.1 doesn't actually have 6A on there. It has 6, but I assume where the 6 is 6A, and I think the 6B, I think the other one is the one below it would be, you know, it says the rest of 6, but it doesn't actually say which is 6A. I mean, I've assumed that because I've seen it before, but it's I think it'd be useful to clarify that.
That's the part that's south of Pack Lane.
Yeah, I think 6A is north of Pack Lane and 6B is below, I think, isn't it? Yeah. Oh, yeah, it's actually on that one, isn't it? Yeah. That's it, yeah. Yeah. Yeah, that's it, because obviously the map in here hasn't actually got them on there, it's a different one, isn't it?
Right, so I'm relieved we are all talking about the same pieces of land.
6A, there we are.
And our next meeting is April, and we are hoping to have the technical studies, expecting to have the technical studies then. So I would thank you all for all your hard work this evening, and bid you a safe journey home. Good night.